Are you a renter in New Zealand feeling powerless? Think your landlord can do whatever they want? You might be surprised to learn that tenants actually have significant rights. In today's rental market, knowing what your landlord can't do is just as important as knowing your own responsibilities. Recent Tenancy Tribunal rulings show that some landlords are still operating under outdated assumptions, and it's costing them dearly. So, let's dive into the top 10 things your landlord is legally prohibited from doing. 1. Showing up unannounced. No pop-in visits allowed. Imagine this: you're relaxing at home, and suddenly your landlord appears at the door, ready to inspect the garden or fix a leaky tap. Unacceptable. Landlords can't just waltz onto the property whenever they feel like it. They need to provide proper notice, at least 48 hours for inspections and 24 hours for repairs or maintenance. And this applies even if they're just doing something outside. Failing to do so could result in them being ordered to pay you up to $1,500 in exemplary damages. Example: one tenant successfully sued their landlord after he showed up uninvited, entered the garden, and started yelling about parking. The tribunal ruled that this behavior breached the tenant's right to quiet enjoyment. But here's where it gets controversial. What if the landlord is simply walking past and notices something that needs urgent attention, like a burst pipe? While they still technically need to provide notice, common sense should prevail. If there is an immediate threat to the property, alerting the tenant immediately is acceptable. 2. Demanding professional cleaning. You're not a cleaning service. This is a big one. Landlords cannot force you to pay for professional cleaning when you move out, including carpet cleaning. Your only obligation is to leave the property in a reasonably clean and tidy condition. Sarina Gibbon, Director of Tenancy Advisory, raises an interesting point about the new pet rules. With the introduction of allowing pets, landlords might try to sneak in a clause requiring professional carpet cleaning if a pet lived on the property. While Parliament used this as an example of a potential condition, each case will be judged individually. Currently, without pets, professional cleaning is not required. And this is the part most people miss. What constitutes reasonably clean and tidy? This is where disputes often arise. Taking photos before you move in and after you move out is crucial to show the condition of the property. 3. Charging a pet bond, yet patience is a virtue. Hold your horses, landlords. You can't legally collect a pet bond until December 1st. Sarina Gibbon emphasizes the fact that landlords have been illegally collecting pet bonds for the better part of the year. If a tenant requests a pet on November 30th and the landlord approves it on the same day, they still cannot charge a pet bond. The approval must occur on or after December 1st for the bond to be legal. 4. Making you pay for their rent loss, not your problem. If you break a fixed-term tenancy and the landlord can't re-rent the property for the same amount, they generally can't make you cover the difference. This is especially relevant in a market where rents are declining. While there might be rare exceptions, the tribunal usually only allows landlords to charge for reasonable expenses incurred due to the early termination, not the lost income. Example: in one case, a tenant broke their lease early, and the landlord relet the property for $10 less per week. The tribunal ruled that the former tenant didn't have to cover the difference because the landlord couldn't prove that the lower rent was necessary. 5. Taking your stuff. Hands off my possessions. Landlords absolutely cannot seize your belongings to cover unpaid rent or any other debts. This is considered theft, plain and simple. One extreme example involved a landlord who threw out a tenant's belongings, handed them a bill, and took their computer. The tribunal ordered the landlord to pay significant compensation. 6. Letting rent arrears pile up. Act fast. If you fall behind on rent, your landlord can't just sit back and let the debt balloon out of control. The Residential Tenancies Act requires them to take reasonable steps to limit the damage or loss. This means they need to act promptly on arrears, such as issuing a 14-day notice or attempting to establish an installment plan. If a landlord waits too long, the tribunal might not award them the full amount of rent owed. 7. Sitting on bills, pass them on. Landlords need to pass on bills, such as water usage fees, to tenants in a timely manner. They can't wait months or even years and then suddenly demand thousands of dollars in back payments. 8. Leaving the country for too long, appoint an agent. If a landlord plans to be out of the country for more than 21 consecutive days, they must appoint an agent to act on their behalf. 9. Bungling cabin questions, it's complicated. The rules surrounding tenants wanting to install cabins or caravans on the property can be tricky. If the cabin is considered a vehicle, it might not fall under the Residential Tenancies Act, and the landlord can't unreasonably withhold consent. However, not all cabins or tiny homes can be brought onto the property without the landlord's permission. Legal advice is recommended in these situations. 10. Retaliating against you, don't be a bully. Landlords can't evict you or raise your rent simply because you've complained about something or exercised your rights as a tenant. This is considered retaliation and is illegal. Example: tenants were given notice shortly after raising concerns about rent and healthy home standards. The tribunal inferred that the notice was retaliatory and awarded the tenants compensation. So, what do you think? Are these tenant protections strong enough, or do landlords need more rights? Have you ever experienced a landlord violating any of these rules? Share your thoughts and experiences in the comments below. Let's start a discussion about creating a fairer rental market for everyone.